Good evening, everyone. Welcome to this special hearing. Thank you, Mark. So this is public hearing to take a look at amending the Springettsbury Township zoning ordinance to incorporate provisions clarifying interaction of the flexible development overlay with other zoning districts.
All right, thank you, Mr. Chair. Good evening, everyone. Tonight we're here for a text amendment hearing. The applicant is Gallery Apartments, LLC. The applicant is seeking a zoning ordinance text amendment to the Flexible Development Overlay Ordinance, Section 325-89 as follows. Applicant requests to amend and modify the text of Section 328-89 .c of the zoning ordinance to add the following new paragraph 4 immediately preceding section 325-89.c subsection 3 of the zoning ordinance as follows. The flexible development overlay described in this article shall be an overlay to any zoning districts to which the flexible development overlay can be applied, and as such, the provisions for the flexible development overlay shall serve as a supplement to the provisions of any such districts upon the application of the flexible development overlay by the Township Board of Supervisors. If the flexible development overlay is applied to any property to which the flexible residential overlay, traditional neighborhood overlay, and/or town center overlay has been or could be applied, the provisions of the flexible development overlay shall supplant the provisions of any such districts upon the application of the flexible development overlay by the Township Board of Supervisors. Where there happens to be any conflict between the provisions or requirements of the flexible development overlay and those of any applicable underlying district, the flexible development overlay provisions shall apply. In the event that any provision concerning the flexible development overlay is declared inapplicable as a result of any legislative or administrative actions or judicial discretion, the basic underlying district provisions shall remain applicable. Right now I'm going to ask Mrs. Bowders, were all notices provided for this hearing? Okay. Okay, and Mr. Heilman, can you please read into record what the submissions were for this? Just the documents, not...
Yes, we received a zoning amendment application from the applicant for this proposed zoning text amendment, and we received supplement to the application. We received a narrative of what they're proposing to do, and we also received some plan drawings indicating where the apartments would be placed in the Galleria Mall property area. And I think that basically is it.
Okay, thank you. I will note that this application was in front of the Planning Commission on October 16th, 2025. The Planning Commission, of those members in attendance, voted for in the affirmative, none in the negative, to recommend approving of this draft text amendment. No conditions were included. The procedure for tonight is the applicant will put forth their evidence and witnesses. After the applicant is done questioning their witness, the board will have the opportunity to ask questions, and then it will be opened to the floor for public comment. If the board doesn't have anything else to add, I will swear in any witnesses and then turn it over to the applicant to begin their testimony. So for anyone that is planning on providing testimony here tonight, please stand and raise your right hand.
You too might.
Do you solemnly swear that the testimony that you are about to give will be the truth, the whole truth, and nothing but the truth? Okay, and just for the record, can we just have them come up and give their names, please? Does that help you out initially?
Brandon Johnson. Jake Krieger from RGS.
Okay, thank you. Attorney Nahila, I
Thank
will
you,
now
sir.
turn it over to you.
Appreciate
Thank
it. Good evening. Tom Nahila from Barley Snyder, once again. I think you're a little bit familiar with this property, but we'll kind of generally do it. It's a 2.5 acre piece of property in the Galleria Mall. We are looking to subdivide that piece off and then build the 98 unit multifamily dwelling. We are here on permission of the both the applicant and the equitable owner. We're an equitable owner in this property. So we were here previously. We submitted a text amendment for off-site parking. That was granted. We were here before asking for the application of the flexible development overlay. We presented a plan. All of that was accepted and passed by both planning commissions and the supervisors. Once we got to that point, we submitted the plan to move forward with land development, and there was an issue that came about. This property is located in your commercial highway district. There is then a town center overlay that goes on top of that, and then there is also the flexible development overlay that we proceeded under to get permission to build this project. There then became a little bit of a conflict of what supersedes or what takes precedent, the town center overlay or the flexible development overlay. And of course, we've taken the position and we have proceeded with the fact that we believe the flexible development overlay supersedes and takes precedent over all of the other, the underlying and the town center overlay. And again, we submitted this and you've already approved the plan that's in front of you. And as a result of that, we came there and then it was this, we hit this little bit of a wall of, well, wait, that plan basically essentially means nothing. And we have to proceed under the town center overlay and go with that overlay, and that one would supersede. We believe that the flexible overlay district really supersedes and should supersede, and that was the intent of the ordinance, because the flexible development overlay can only apply if you, the supervisors, grant approval to allow it to apply. It is completely 100% in your sole discretion. You have flexibility, you have control over all of that. It's not a permitted use, it's not a conditional use, it's not a special exception. It is 100% in your discretion of whether you apply the flexible development overlay. So, one of the uses in the flexible development overlay is multifamily apartments, and that is why we proceeded under that section. The town center overlay has a whole different procedure to follow. You have to submit a conditional use plan, you got to walk through there. The problem is, and the reason we did not go under the town center overlay, is the town center overlay doesn't allow for multifamily developments. So we right now could not walk in and ask for the multifamily apartments under the town center because it's just not allowed. It's not even one of the conditional uses under there. So we proceeded under the flexible development overlay, and again, that overlay gives you guys discretion. There's a lot of requirements in there that we needed to hit. So it's not like we just applied for it and it was granted. The way the ordinance is set up is there are certain site design criteria that needed to be met. There's building form and materials that you guys control. There's lighting guidelines, there's landscaping, there's integration of surrounding areas. So there's a lot of requirements that needed to be addressed, which we addressed in the plan that was presented to you. Again, fully in your discretion. So if you didn't like any part of that and wanted I mean, I'm going to go to an extreme. If you wanted us to build a moat around that building with a drawbridge, you could have said, build a moat and we'll grant it to you. Otherwise, we're not granting it to you. There are design criteria in there, which we followed and we presented to the plan. So our current request now, because we have this little dilemma, is to introduce the text amendment that basically would simply say that the flexible development overlay, again, I'm going to sound like a repeated or a broken record, completely in your discretion. But if you decide to allow that to be applied, that overlay wins over any other overlay. And that's sort of the crux of what we are asking for. And then we submitted the application. As we mentioned, we were here before. We asked to allow the proposed text amendment to proceed. You guys said yes. We took that to the Planning Commission back in October, got unanimous approval. The discussion there seemed to surround around the same fact of, we already granted you this right. And I said, yes, you already did. But if I have to now come in and comply with the overlay, everything we did is basically out the door and we have to kind of start all over again. So I think the Planning Commission understood that and said, we get it. We're okay with the text amendment. So we've moved on from there. And again, last time we were here, we talked about, look, if you allowed this text amendment, there could be sort of unintentional consequences. Again, we think the ordinance already is set up to deal with those unintentional consequences because, again, this is solely in your discretion, not a permitted, not a conditional use where if I hit 12 requirements, you have to grant me that. It is in your discretion to say yes or no. And again, you did say yes, and we presented the plan. So we've been talking about this back and forth. We did get Randall's summary, and again, even in that summary, it was, and we actually talked to Marion, your outside consultant, that was sort of like, well, the argument was sort of the flexible development allowed for the use. So we were allowed to use multifamily there, but as we proceeded forward, then we had to comply with the more restrictive overlay, which in their understanding would be the town center overlay. But my concern with there is if I have to comply with the more rigid overlay and I go to the town center, I'm then into an overlay that does not allow for multifamily. I can't ask for a conditional use, or you'd be granting a right for me to build something that's not even allowed in the town center overlay. So I think I don't think that really can work. So that is why we are not proceeding in that direction. So we are, so again, that's sort of where we are, because we're at a little bit of a dilemma, because in the event that we have to try to comply with this, we have to submit a conditional use for a conditional use that doesn't exist. And we think that's probably more worrisome of unintentional consequences than allowing this ordinance to go through, which would allow the flexible development to kind of take precedent. But again, it comes back to you're in full control of anything that goes through the flexible development. That's sort of a summary of where we are and kind of a roundabout of how we got here. I'm open for questions, concerns, whatever you want to talk about.
So,
Go ahead.
so are the mechanics of this flexible development overlay, if the supervisors impose it on a property, is it there forever until we change zoning again? Can we revoke that? What are the mechanics of that piece?
If you grant the application of a flexible development overlay to a particular project, our project, then yes, it would be allowed going forward, as always.
Okay. And we could revise the zoning for the future, but it would be grandfathered in.
Yes. So, fast forward, I know you guys are considering a new ordinance. You do a whole new ordinance. If you change the entire zone in this district and in this area, yes, we would be a grandfathered project under that.
Right.
If you change the ordinance and it didn't apply and comply
In
anymore.
the future, right. Okay, so then to that point,
Are you aware there is a zoning ordinance proposed change for the Galleria consistent with our comprehensive plan that would permit the apartments? residential?
I am aware of it. Mark did share that with us about 2 days ago of the actual text of it. And again, we know that's going to come somewhere along the line, probably within the next, I don't know, 4, 5, 6 months into the new year. We did look at it. We haven't studied it in detail. There's what we have as a glaring concern with it is that the density that is being proposed under your new ordinance for this Galleria Mall is 20 units per acre. So our 2.5 acre piece would only allow for a 50-unit multifamily house or multifamily project to be developed there. We are at 98, which is what you've already consented to under the flexible development. So we'd be losing half of the units. And I personally feel in working with developers to do multifamily, you will kill that project, whether it's us or anybody else, because there is no one that is going to come in there and build a high-end multifamily apartment complex with a density of 20 units. A 50-unit building it's not economically feasible. And I know you can say, hey, I don't care about the economics, but if you really do want to develop this section for alternative uses, including multifamily, a 20-unit density will kill that project. That's why we're at 98. I mean, but, we kind of push that in there, and again, it's a 3-story. We're not going higher than that, and we're trying to. If the intention of this is to take a dying mall, or what could potentially be a dying mall, and reuse it, and have an area of your township where you want that reuse to go, it needs to be allowed to kind of infill and make that economically feasible, or it just loses its purpose.
What specific parts of the town center overlay are interacting with the flexible development zone that would not allow you to do what you need to do?
The first one is the use. The town center overlay
Off the
does
use.
not
Let's
allow
get
for
off the use
multifamily.
Because I might disagree with exactly how that stacks on there, but what other parts of the town center overlay are preventing you from doing what you are trying to do here?
I can get Jake or Brandon to probably go through a little more of the details of it, but it significantly changes what you previously approved. Jake, you want to kind of walk through just some of those, or Brandon, some of those differences?
I guess is your question reference to the new town center or the current?
The current town center, how does that impact the underlying use and the flexible development zone that are approved?
Yeah, so some of the other differences are related to setbacks, building setbacks, and buffering. There are some additional pedestrian access ones that we would generally be able to meet, but that we don't comply with currently. And I think the other big ones are the setbacks and the buffers, are the kind of the main ones.
So it does not require upgraded finishes or anything different that way that would add to the cost of your project. So it sounds to me like if the flexible zoning, flexible overlay grants you the ability to put multifamily in there, that there's not that much difference if you comply with the town overlay as well. Buffering and a couple of pedestrian exits.
Well, it's more the setback. I mean, it does have an effect on our setbacks and on the building. It's the footprint.
There's not a difference in the building footprint, but I believe there's a difference in the impervious cover as well. That's different.
That will impact the overall development.
Yeah, that would be another one that impacts it. I can't remember the number off the top of my head of what it is.
Yeah, I think town center also requires a master plan level of submission that we're not planning to go through, we wouldn't have needed to go through. So I think really in summary, I mean, that is so critical that the use is not allowed under town center. It's not listed, it's not permitted by right, it's not conditional use or a special exception. It's why we went to you back in the spring, you approved electively applying the flexible development overlay to this site in the spring. Totally at your discretion.
It's completely the reason we didn't go under the town center overlay right from the beginning. Because if we would have did that, we would have saved about 6 to 7 months, because we went this way, and we went through the whole process because your town center did not allow for that use. So we went through to the flexible because it did allow for the use. And that's kind of where we
Look at that
went.
from the other direction then. What does the flexible development overlay give you that the town center overlay doesn't, that you absolutely need, other than the main use of the residential units?
It changes the plan entirely, again, because of the use. I mean, there's the building, that's what we're planning. Without that, in town center, it's a totally different thing. What you're
So-
allowed to do in town center, you could put a restaurant there maybe, or
No, I'm saying,
some other
I'm
things.
saying, take a look at, outside of the use differential between flexible development and town center, what are the differentials between the two? What does the flexible development give you, other than the residential use, that you don't get in town center overlay, or that impose a tremendous burden on you?
If we have to do it, we have to start all over again. We have to
Okay,
submit
you're-
a whole new
I don't
plan.
think you're understanding.
I think I am because, see, I think that's our issue, is because under the flexible development overlay, you had full discretion. So I guess my question back to you is, what is it in the town overlay district that you guys want now that when you approved that plan, you didn't want? That's what I can't understand, is because you had every right 6 months ago to say, I want a moat around that building. You have to build the moat in order for us to give it.
No, you're using ridiculous statements to try to prove a point that may not be valid. So I want to get away from that. I want to talk specifically about what the town center overlay does to your project.
It starts the,
Specifics, not,
it starts
close
the,
it up and we have to start all over.
well, it
It's
starts
not
the
the
clock
answer
all
on-
over again. I have to submit a whole nother master, I think it's a conditional use plan and a master plan that we're gonna have to go through and re-engineer everything that we have engineered so far. We gotta start all over again and re-engineer all of that to kind of come through with another, there's kind of like 3 different steps under there before we would even get the land use plan. And that's kind of where we were gonna have to start. We didn't start there because it didn't allow for the use. We went to an overlay district that did allow for the use, that is allowed to be applied in this section,
Tom,
and that's kind of where we
I've got a
started.
comment. You've made that comment about 5 times now. The answer is you would never have submitted this project because that use wasn't permitted under the town center. So
I couldn't.
You didn't choose not to go that direction. You wouldn't have been able to go that direction. So you chose the flexible zoning. We've tried to accommodate you as much as we can. What we're saying is there anything in the town center overlay? Forget about starting the clock over and having to do a master plan. If the flexible zoning overlay grants us the ability to waive some of those requirements, what is it in, all I've heard is pedestrian entrances and maybe some setback issues. Is there anything else that it changes?
It's it's a tough question to answer because it's out of context without the use, right? But it's the flexible development overlay is what allows us to build that plan that you see right there, the 98 units, the 4-story building, all of those things.
I'm not saying
Right.
we would stop using the flexible overlay. I'm saying if we use the flexible overlay, and our interpretation was that it gives you that use on top of the town center overlay, is there anything in that town center overlay that disturbs your project, that makes it unfeasible for you, that doubles the cost? I'm just looking for something there. And you ask, what do we want in the town center? We don't know what we want in the town center overlay because you didn't go that direction.
Right.
So we've never seen a plan that was, because it wouldn't have made any sense because the use wasn't permitted.
Sure. Just a couple things just to look at the setbacks. So setbacks would be different because they're looked at from a curb line versus a property line. So that pushes our setback and our building back, which impacts. You can see how it fits into the parking. That would shrink the building potentially because of pushing that back. The impervious cover, the flexible development allows 50% building coverage, whereas the town center, it requires 85% maximum impervious cover. So we're going from a site that's pretty much 100% impervious, and we are adding some green space, but to meet an 85% impervious cover would be more difficult than a 50% building coverage. And then another big item that I didn't mention before was the town center does have a lot of requirements for along streets. And so we're viewing the loop road kind of as our frontage and our street, and I think your staff kind of agrees with that. But there's requirements for parking and planting islands and all street trees kind of along a public street, which would be hard to do in this instance because of where we're located. So, and because of the zoning, we wouldn't be able to just waive street trees. It would be a zoning action to be able to not to do those.
So due to those setbacks, it potentially is going to shrink our building
Yes.
because we're going to have to deal with the setbacks and the impervious coverage. It will impact that building. We will not be able to build the same building with the 98 units.
Okay.
Mr. Luciani. So I'll ask you if the flexible overlay superseded the town center overlay, what would we lose that we're looking for?
I think the town center overlay, as we all know, promotes this walkability and those kinds of things. And I think at that point, making this development, because you're going to have residents there, they may not all be, they may be families that are living there. I think the testimony from the applicant was they gave some specifics for their Hershey projects, if I recall correctly, that there weren't a lot of children. I think the number of units that had multiple bedrooms were pretty few. But we need that, now that we have people there, they're going to want to go out and go to the park or things like that. So those features, those pedestrian features would be built in as part of that town center, which may not occur if we skip that format. That's what I saw when I reviewed both ordinances.
And again, not to sound like, again, I apologize, but if you wanted that, when we brought that plan in 6 months ago, you could have said, I want a sidewalk, or I want you to, I'm not sure what exactly the pedestrian walkway would be within this mall. I mean, we could stripe that, we could stripe a path to get you to the mall, but whether people will walk on that path or just walk through the parking lot, I'm not sure gets us there. So I'm not exactly sure what pedestrian access ways you wanted, but 6 months ago, when we brought that in, you had full discretion to say, I would like sidewalks, or I would like striping, and we would have had to do it.
6 months ago, our expectation was we were granting you access to build the 98 units that you were looking for, not that we were taking away the rights of the town center overlay. So your understanding there must have been different than ours, because I don't think that that's what we thought we were approving. I don't think that that's, I mean, I think that's why you're here tonight, because it isn't what we really approved, to let you do whatever you want without regard to town center overlay at all. So we're at this point now where there are some small things that you might have to deal with if you're going to do town center overlay and we don't make this change. But it doesn't, I haven't heard anything that's major and undoable here. I mean, I guess I'm kind of at a loss as to why we're spending so much time
I agree.
arguing about this.
Can't we
when-
Actually-
grant waivers for anything that would be restrictive in the town center overlay?
You can certainly,
Is that an option?
The reason that,
yes.
oh, sorry. The reason we didn't, we have our land development plan ready to go, package, we were ready to submit in July. And the reason we didn't is because when we met with staff, we realized that there was some confusion about which should supersede. Like Tom said at the intro, there's commercial highway, there's already a town center overlay that everybody looking at your zoning map sees on this site. And then electively, flexible development overlay was applied to this site at your discretion. So normal overlay language will say, in any ordinance across, PA, like in the cases of a conflict between the provisions of this and another, and an underlying district, this shall supersede, right? And the whole origin of us being here tonight rather than submitting our land development plan is that we just need to provide clarity that the flexible development overlay supersedes both the commercial highway and the town center, because it was added most recently. It's the top layer. It's the only way that we are able to do what we're doing, because otherwise there's confusion about, which setbacks do you use, which set of uses do you use, all of that. I would say it was an omission in the text of the flexible development overlay when it was written, that didn't provide that clarity. So we're getting that clarity with this text amendment now. That's what we're seeking.
And we're not proposing to build anything we want. We did, under the flexible development overlay, have to provide a plan. So we did provide a plan. If it was only for use, we would have came in and said, hey, can we build a multifamily apartment in that parking lot? You would have said yes. We would have said, okay, and then we would have then had to do a different plan. We had to submit a plan with the request for the flexible development overlay, which you approved. And we now have to go through land development, your whole land development process. It's not like we can now just build anything we want. So it's not like we didn't have some design criteria that we had to meet in a plan we had to present.
So James, I have a question. If we grant this flexible development overlay text amendment as stated, but yet we're coming down the line to adopt some of the ordinances in the comprehensive plan, depending on timing, just presuming perfect world timing, would what we approve here today be then superseded by what we would approve down the road?
I'll be careful with how I answer this because.
And I was trying to be careful how I ask.
No,
too.
I understand. Yeah. I understand what you're asking. So the underlying law is when you submit a plan, you are subject to the ordinances in place at the time of submission. And that's to Tom's point, that's the grandfathering. If you were, and again, not being totally to have my arms around this pull-out draft of the Town Center Overlay Galleria district. But if that then says this controls and the language says it supersedes all other overlay provisions, then yes, any plans upon adoption, after the whole process of doing a zoning ordinance adoption, upon adoption, any plans submitted from the adoption date forward would be subject to that new ordinance. So you'd kind of have a gap here for whatever if whatever you do with the text amendment tonight through to when whatever you would do to replace that section.
For lack of a better term, the flexible development window.
Correct. Yes.
Okay, which could be 5 months, could be 6, could be whatever,
Wh-
whatever period
however
it takes.
you choose to proceed, but yes, that is essentially, you would be opening a window to allow for this text amendment. And to Attorney Nahila's point, it's not a guaranteed permission that you're giving just for somebody to kind of backdoor in with the flexible development overlay. You have to approve that.
Exercise discretion on a case-by-case
You
basis.
absolutely, it still has to go through the conditional use hearing with you on the flexible development side. And at that point in time, now that you know that this is here, and again, I'm not trying to sway you one way or other, I'm just trying to tell you what kind of the parameters are. You can certainly say, well, wait a minute, I know I've got this town center overlay sitting out here, and does this project sit with that, or does it more appropriately sit with this? Again, I'm just knowing what Attorney Nahila was presenting here. That's their case. But to your question, it is a window or a way to put developments such as this, where again, it's not being addressed because the language isn't as clear in there. Does that answer your question?
It clarifies my understanding.
All right. Perfect. Thank you.
Any other questions from the supervisors? Mr. Bishop, anything? Mr. Dvoryak? Then I'll move on to members of the public. Is that
Yes, and for the members of the public that wish to comment, this is not a question and answer session. This is a public comment session. So if you have comments on this particular text amendment, please come up to the microphone.
If there's anybody on Zoom that has a comment, please click the raise hand button. If there's anybody in the audience that would like to address this, please raise your hand. Seeing none, we will move to, is this closure at the?
You can close the hearing. We can go in executive session. You can vote on what you want to do. It's up to you.
Is this is
The
listed
ordinance
in?
is on the regular meeting.
It's in the regular meeting.
The ordinance has been advertised, and it is on the agenda for approval or vote on approval
Yeah.
In the regular meeting.
in the regular meeting. So
So we could close this meeting and then pick it up, any discussion there, and vote.
yes, that's,
Discussion
Well-
about what we want to.
no, we needed a decision out of the hearing is what we need.
Oh, a recommendation to the board
Correct.
out of the hearing?
A recommendation to move, to permit the approval in the Board of Supervisors meeting.
To
Not that you're approving the ordinance, that,
permit the vote.
to permit the vote. That's right.
Mr. Chairman, I move to essentially permit the vote on this proposed text amendment.
Second.
All right, I have a motion and a second. All in favor?
Aye.
All right,
Thank you.
carries unanimous. Meeting adjourned. Thank you. Good evening, everyone. Welcome to this regularly scheduled Township Board of Supervisors meeting. Our first item this evening will be a pledge to the flag. Please join me. We did have one executive session since our last meeting on December 8th for purposes of a real estate discussion and collective bargaining. So at this point, I would like to open up the floor to communication from citizens. I would like to ask that since we have a fair number of people in the room, that we keep comments to 3 minutes. Please follow appropriate decorum in discussing or addressing the board. This is for comments, not for cross-examination. If you are a citizen of the township or a business owner that pays taxes in the township, you are welcome to address the board. Everyone else, I would ask that you please address the township in writing or through email. If you are on Zoom, you can click the raise hand button to be recognized, and if you are in the audience here and would like to address the board, I would ask that you raise your hand and be recognized. When you come to the podium, I would ask that you give your name and address for the record, and I would now open up the floor. Anyone? Yes, please.
Good evening. My name is Ryan White. I reside on 27 South Kershaw. Ryan White. I'm a resident and taxpayer in the old East York Fayfield neighborhood. And while this is my first time addressing a township meeting, I have previously sent email correspondence, and I thank those of you who have engaged with me in thoughtful discussion. I am here this evening to add my voice to my neighbors and the substantial majority of York suburban voters who reside in Springettsbury. As we know, York Suburban has been seeking this board's approval to construct a new modern intermediate school. This process has been stalled for some time due to this board's hesitancy. And I know from our email exchanges that one of those cited concerns is the preservation of neighborhood integrity. Honestly, I remain uncertain how a new neighborhood school on the site of a current neighborhood school jeopardizes neighborhood integrity, but I have given it some thought. And I've come up with 3 ideas that I think would have a far greater impact on preserving neighborhood integrity than opposing a new school. So I thought I'd offer those 3 proposals for consideration. The first one, how about an annual neighborhood tree replacement program? We've all witnessed neighbors removing aged and diseased trees. Many are never replaced. So I would propose that Springettsbury solicit local nurseries and invite them to participate in a bulk order scheme where entire neighborhoods would be offered a significant discount on the purchase and planting of saplings. Neighbors would benefit from economies of scale, nurseries would benefit from an influx of orders and efficiency, and the township would benefit by restoring our beautiful tree-lined streets for another generation. And best of all, the township would spend no money. Homeowners would save money, and local businesses would make more money. I bet this is an initiative that could be tasked to a junior staff member and could be implemented in a matter of months. My second idea, a pedestrian safety initiative. For anyone like me who enjoys walking the streets of our community, maybe a quick run to Wise or just walking around an adjacent neighborhood, you've surely encountered sidewalks that abruptly end, or crosswalks that lack pedestrian signals, or traffic signal intersections that have no crosswalks at all. To truly improve the integrity and safety of our neighborhoods, I would urge you to launch a pedestrian safety initiative that would focus on our major thoroughfares like Market Street and Eastern Boulevard.
Please wrap up your comments.
My third idea, addressing corporate ownership of single-family homes. This is tough, but I believe it poses the single greatest threat to the long-term integrity of our neighborhoods. Take a short drive and you'll see for rent signs in front of single-family homes owned by corporations. And while renting and investing in properties are not inherently wrong, the blight of corporate ownership is well documented. Inflated prices, supply disruption, and of course, disruption to the community with increased evictions, a more transient demographic, and diminished wealth building opportunities for families. It's not an academic problem.
Please wrap up your comments.
It's happening right here. And while we're debating the merits of a new school, corporate landlords are exploiting our inattention. So I would challenge you, if
Thank
you
you.
genuinely want to protect the integrity of our neighborhoods, turn your attention and resources to finding a way to rein in this epidemic.
Thank you for your comments.
Thank you.
Is there anyone else who would like to address the board? Yes, please.
Hello, my name is Samuel Piercy. I live at 3207 Rex Drive here in New York. Pardon? How do you spell your last name, sir? Piercy. Thank you. So, I'd just like to note the juxtaposition of the building that we're sitting in. This is phenomenal. This is a great building, absolutely beautiful. It's quite different from the schools, which are kind of cold. Anyway, I remember as a kid, people would be excited for new schools. They would celebrate new buildings, better places for their children, cousins, nieces, nephews, grandchildren, to be educated in better spaces with better equipment than they could have imagined. My Board of Education as a kid needed to sell the community on raising bonds and levies to pay for buildings and land. The homeowners near new construction always complained and bemoaned the equipment, the noise, the dust, and the changes. They'd say, this is too much, this is too expensive. They would go on about not in my backyard. But you know what? After the buildings were built, the community really could see that final product, and they were proud of what they built together. A better space for the community. Not only the students benefited, but the homeowners saw increased home values, and the immediate neighborhoods benefited from the event spaces and the approved curb appeal. The community voted. The community believes they can afford to invest in teachers and buildings, but the community can't make that long-term investment without approval from this board. Of course, there's an alternative. They could retrofit buildings built before 1973, an era before schools were integrated, before lead paint was banned, before asbestos was banned from insulation, flooring, or drywall, before lead pipes were banned from new construction, before accessibility requirements, which this space is fantastic, and before active shooter drills. Build a new building, no lead, no asbestos, lower operating costs, more accessible, more secure. Any delays in starting construction waste everyone's money. We're wasting time against inflation. We're wasting money heating old buildings that are drafty and cold. And we're wasting money on waiting for approvals. I'm here to support new buildings that my kids won't use, but maybe we can be proud of once completed. Thank you.
Thank you. Anyone else? Yes, ma'am.
Louise Soskin, 2467 Schoolhouse Lane. I've been up here many times before, and my opinion has not changed that I'm opposed to this project for many reasons. There is an integrity that will be changed if you bring everyone from Indian Rock over to East York Elementary. Those roads, which I live on Schoolhouse Lane, they're not meant for the traffic that would be coming over. The roads are not wide enough. We are allowed and we're entitled to park on both sides of most of the roads in that small neighborhood. If you decide to allow the no parking on Sundale, it will affect the residents in many ways. One of them is, well, a couple. One, the people that park on Sundale, as well as all of the people coming over from Springettsbury Township, they'll just spill over onto our streets, onto the other streets. Right now, we can barely get buses, EMS trucks, Amazon trucks through the small streets. The basic preface is that it's going to make the neighborhood better. I don't see how the unbearable, as the gentleman said, there's going to be construction, there's going to be destruction, there's going to be noise, there's going to be dust, there's going to be possibly health issues, there's going to be, I don't know if it ever got addressed, the engineers clearly said in their paperwork, not once, not twice, not 3 times, but 7 times, that sinkholes will happen. We can't just assume that everything on paper is going to work as it is. Just like when you do your no parking signs. Right now, when I went out and, took my pictures before, there were cars parked in front of the fire hydrants. There were cars parked in the crosswalks. There were cars parked in the yellow. Just because they're parents does not mean that they're going to listen to everything. Right now, they're not. And that's the madness that I agreed to. That's what I understand, that I knew what I was buying. What I am not interested in is having my small neighborhood pretty much crippled and the way of life that we have now completely changed by the influx of new students. Thank you.
Thank you. Yes, sir.
Danny Barker, 740 Sundale Drive. There's a rumor afoot in the neighborhood that a request is being brought forth by the venerable leadership of the school district to limit parking on some or all of Sundale. As a resident who's been there, my wife and I, for 23 years, we simply request that you deny that request if it comes before you. It unquestionably changes the characteristic of the neighborhood, and thank you very much.
Thank you. Yes, ma'am.
Hello, I'm Brenda Enders. I live at 720 Sundale Drive. I've been in my residence for 37 years, and the way they were talking is like no parking on Sundale. Well, to me, that's a concern. If I would ever want to sell my house and they had more than, parking, no parking in front, I couldn't sell it. And that's one of my concerns. And like the water conditions and stuff. And my whole yard in the back has changed over that 37 years. It's very wet. And where my fence is, all back there where they dug and stuff, when they dug, did they do 2 feet or how far did they go for the water? Does anybody know? Because at one time back there was a whole flood area. All the cars were flooded in the schoolyard. So, and I said that, I addressed it before, like when they start digging, it's all back there is a whole spring. It used to be all farmland, and it's all springs back there. And my neighbors, they have a sub pump. Now, I don't have no water, but my neighbors do, and across the street from me, they have water problems. So this is, when they start doing this, it's going to be a problem. But my problem too is the parking. If I want to sell my house, there's no parking. Even if I have company, where are they going to park? Are they going to have to go to another street and park and walk to my house? Because there are other areas, I pay my taxes, but other areas in the streets, they can park in front of their house. And I don't think that would be fair to do that. So that's just what I have to say about it.
Thank you.
Okay, thank you. Enders, E-N-D-E-R-S.
Is there anyone else who would like to address the board? Yes, sir.
How are you this evening? My name is Brad Lehr. That's L-E-H-R. I live at 2461 Pleasant View Drive. It's in Pleasureville, down the street from the Hawks Club. Just last week, I received an ordinance violation letter. I have chickens. I've had them for 10 plus years. Even when I got them, I called because in the codes it says about you're allowed 6 chickens, but apparently it's R20 district. I'm in R7. Didn't even know there was a difference. And I guess there was some miscommunication with the person I spoke to on the phone because I have 6 chickens. I had called to see if there's any setbacks for coops, that kind of thing. And told me no, there wasn't anything. I was allowed to have the 6 chickens. So Like I said, I got this letter, so what I'm just requesting is that I'm not going to get any more chickens. They're over 4 years old plus now. They're not going to be, living that much longer. If I could just at least keep the chickens, because they're really no good for anyone. It's not like I can give them to somebody even for eggs, because I get very few eggs now. So I'm just asking maybe if you could allow me to have the chickens. I won't replace them just until they die. There is also a possibility I'm moving in June because transferring for a job. It would be out of state. I would take them with me. So if I can at least keep them till then, or until they die, so I don't. And like I said, I won't replace them. I did get all my neighbors. I mean, they all love the chickens. I did get them to sign a petition. They all have no problem with the chickens. In fact, they actually wanted to get some. They didn't realize either that we aren't allowed to, and we're in a different. Like I said, it doesn't say anything about R7 or R10. It doesn't explain that. It doesn't say one way or the other. And I didn't realize when I spoke to the person on the phone that there was a difference. So I'm just asking if I could keep them until, like I said, until something happens to them or we move.
So I'm not sure how we're going to handle that here right now tonight. I
Yeah.
would suggest
talked
that
to
you,
Mr.
I would
Heilman,
suggest
and
that
he
you
just
talk
suggested
to
I
the
come here.
manager and we address that issue separately.
Okay. All right, yeah, I talked to Mr. Heilman. He just suggested I come here and
Okay.
just give you the information. So
Thank you.
just talk to someone.
Yeah, call in and ask for the manager, and our manager will talk to you about it.
All right, I appreciate that. Thank you.
Thank you. Anyone else this evening? All right, then we'll move on. Our engineering reports. Diana?
Good evening, gentlemen. I have no updates to the report that was submitted. If you have any questions, I'd be happy to answer.
Any questions?
I have a question about the resurfacing of 24.
Yes. I did get an update on that, and that is supposed to happen this spring, supposed to start this spring.
So it's not happening tomorrow?
Not that I know of. No, they told me. No, they said originally it was to be let in December. So that just means the contract will be starting up. Actual construction would be
Great.
a little bit later.
Thank you.
Mm-hmm.
Thank you. John?
I just have two quick updates. As you know, we have our federally funded TASA grant for sidewalks out there at the Giant. And the feds have changed their lighting standards so that when you illuminate one side of the road, you have to illuminate the other side of the road. And of course, our Giant project was budgeted and funded to provide our typical street lights on the Giant side. So we were wrestling with how we're going to handle that issue, and fortunately, there are Cobra lights on the other side of the street. We had a meeting with the PennDOT, and they said, yeah, you could use those lights as part of your illumination. So that solved another hurdle that held us up for a little bit. So we will be resubmitting that information to PennDOT, and hopefully we'll be ready to build the sidewalk in the very near future. The other thing I wanted to mention is I attended a NPDS seminar at your college, and the requirements for stormwater and percolation and all that are going to significantly increase for developers because PennDOT is requiring, or not PennDOT, I'm sorry, DEP is requiring significantly more testing to verify infiltration and those kinds of things. And it's going to be a challenge for developers. You're going to hear there were thousands of comments on their new regs, but they're moving forward with adopting them, and developers, I'm sure, will feel the pinch to move forward with their stormwater and post-construction stormwater management plan. So another challenge and more difficult things to navigate for various developers. If you have any questions, I'd be glad to answer them.
Questions? Thanks, John.
Thank you.
Next, we have our consent agenda. items 5A through H. Any items on here that anyone would like to have removed for further discussion?
Mr. Chair, I'll make a motion to approve consent agenda items A through H.
Second.
I have a motion and a second. All in favor?
Aye.
Aye.
Next, we have bids, proposals, contracts, and agreements, authorization to approve scope of services for Buchard Horn for East York Pump Station rehabilitation construction phase in an amount not to exceed $124,500.
Mr. Chairman, as you recall, the board approved the rehabilitation project at East York Pump Station a meeting or two ago. This is for Buchard Horn to provide construction management and inspection services, and it is included in our budgeting.
Questions? Do I hear a motion?
Mr. Chairman, I would move for authorization to approve the scope of services with Buchard Horn, Inc. for the East York Pump Station rehabilitation construction phase in an amount not to exceed $124,500.
Second.
I have a motion and a second. All in favor?
Aye.
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 All right, next we have land development 2024-003, New East York Intermediate School.
Obviously, the supervisors have seen this plan in numerous iterations, and we obviously have represented members of the school district here this evening, as well as legal counsel. We have their consultant here. So I'm just bringing that to the attention of the board, and with that, I'll turn it over.
Good evening, gentlemen.
Evening.
Unless you want a background on this, I think we all are familiar with where we're at. We have gone through and addressed numerous comments from back and forth from your engineer, your zoning officer, and the like. We believe there are three large outstanding comments to address. They have to do with the utility easement and the access drive off of Sundale coming out and touching that. Has to do with noise, and it has to do with the no parking or the turning restrictions from Sundale or from the access drive onto Sundale. We are asking for some sort of parking restriction on Sundale. However, it's limited in nature. It's limited to 2 hours a day from August to June, and we believe it only impacts 3 to 4 parking spaces at the most. We have heard the concerns of the residents that there will be impact on their homes, and we believe that this is a way to mitigate those concerns of the parking in those areas with regard to the turning restrictions, but at the same time providing a reasonable accommodation to have the school buses turn out at that location in a safe manner. I will have Brian Schuster from K&W come up and walk you through that. However, the second thing I would like to point out on the utility easement is that was an issue. There was a question from the very start of this project as to who owned and was responsible for the maintenance of that easement. The school district realized it was in the township's hands, but given the circumstances we're at today, the school district is willing to take over that easement, extinguishment, and then become responsible for that utility easement from Erlin to Sundale. So we would take that off your hands. No impact on the taxpayers if it's damaged. We believe it has a lesser impact. What we're proposing has a lesser impact on that easement, but understanding the concerns of the township, we are willing to take that off your hands. And with regard to the noise, I'm going to let the architect talk about that because I'm not well versed on that side. So we did provide. I am a solicitor, so I do understand the requirements for restrictions. It is unique to ask a municipality to assist a developer with a condition on putting no parking restrictions in place. However, the school district cannot do that. We have no authority to do so. So we have prepared a parking study in accordance with motor vehicle law and second-class township code that would demonstrate the justification for limitation of parking in this area. However, again, we've tried to restrict that as much as possible with our ask. So, Ryan, maybe you could come up and walk the board through those concerns, or that issue.
Yes, for a second, I'm going to hand out a few exhibits here that we created. Oh, yeah, thanks. So the letter that we received has two remaining comments regarding the parking and the turning movements coming out of the access on the Sundale Drive. One of them is talking about the buses turning left and heading northbound along Sundale. The first exhibit that you'll see there is to show how there is actually an existing driveway on the eastern side of Sundale Drive. So there will not be parking spaces along that curb line that will be impacted by that turning movement. The second exhibit you'll see within that packet shows a plan that was part of this land development submission that details the hours that we are proposing to restrict parking. And you'll see that it's only a few hours a day, like 1 hour in the morning, an hour in the afternoon, only during weekdays and only during days where school is in session. And like Dave mentioned, that is to minimize the parking impacts to Sundale Drive to the greatest extent that we can.
Did the board have any questions on these exhibits for Mr. Schuster?
What hours again were they going to be restricted?
It would be 8 a.m. in the morning to 9 a.m. in the morning, which is our bus drop-off, and then 3 p.m. to 4 p.m. in the afternoon, which is the pickup and departure from the school.
So 4 interruptions. One, they'd have to move at 8 and then come back at 9.
Correct.
And then in the afternoon and back.
3 to 4, correct.
Okay.
And the township ordinances do have a provision that relate to Section 31232 that prohibits parking in certain locations during certain times. So you have a section of the ordinance that always addresses something along these lines. One thing I would note is this is public parking. So at the school, we're providing for parking spaces. So if folks have visitors, holidays, weekends, they're free to use those parking spaces in addition to the on-street spaces that are there. Perhaps we can have Seth Wentz come up. He's the architect to talk a little bit about the noise provision.
Sure. Seth, S-E-T-H, Wentz, W-E-N-T-Z. Including the last submission package was a plan we developed after being requested to analyze the noise impact from noise-generating equipment on site. That plan shows the rooftop units. The building is conditioned by package rooftop units. They are indicated in red, overlaid on top of the building footprint. Each one of those has the distance from the rooftop unit to the boundary line of the site, as well as the original noise generating from the unit, and then the distance calculation and how it reduces by the time it reaches the property boundary. In each one of the cases, these rooftop units produce less noise and decibel levels at the boundaries than required in the zoning. In addition to that, what this does, it's a conservative estimate, meaning that these units, in addition to having the distance from the property line, are elevated. So it's actually a greater distance than what was calculated. So these are actually proving that we're under the decibel levels without the elevation difference being considered. The one unit that does generate noise beyond what's allowed is the generator, and that's noted at the 64.6 as opposed to the 54 required. When this was pointed out, it was after the project had already gone out to bid. We had discussions about how to remediate the noise generated from that unit. There are noise dampening enclosures, and we have that information in the lower right-hand page of that exhibit. We would propose, if this is approved, going to the contractors and issuing a request for proposal based on a delegated design enclosure. What that means is that the contractor is responsible for coming up with the enclosure performance based on the specification that we write for performance requirements at the boundary. They'd be responsible for designing it, installing it, and then most importantly, post-installation testing to verify that it works. That is the nature of the delegated design. They're responsible for testing and proving. As far as the other noise generating equipment, we were also asked about speakers mounted to the building. I do have the exhibit of the speakers there. They are going to be tested after they are installed and tuned down. They are tunable, so we can control the volume on those so that they do not violate the zoning. Lastly, as far as construction activities, we do have in the specifications that the contractors bid on requirements for hours of operation. It aligns with the zoning for the township, and I believe that is listed there within the specifications and in section 325146A2 of the zoning. So the specifications are modeled after those constraints. As far as construction activities, the school district has employed a full-time construction manager, Fidavia. The construction manager is responsible for making sure that all contractors abide by the specifications, including the noise restrictions outlined that I just discussed, and they are able to act as a liaison for the neighborhood. If there are concerns about noise generation and whatnot during construction, they're able to talk to the residents, coordinate with the contractors, and if something is needed, communicate with the district as well. Thank you.
Does anyone have any questions for Mr. Wentz? Okay.
Anyone?
I'm good.
Hearing none, the school district also, there was also a couple more comments. I think one is with regard to the waiver. I think that's something that you gentlemen understand. You've dealt with those in the past. With regard to the requirement for the O&M agreement, the school district meets on the 22nd, so should this plan be approved conditionally, we would have a signed O&M agreement to you shortly thereafter. We have received comments back on the financial security estimate from Mr. Luciani's office. We're addressing those appropriately. The school district has the wherewithal to obtain its financial securities in accordance with the requirements of the MPC and the township. I will say, I think the school district has gone through its paces. Your township engineer and your zoning officer has made sure that we've met the requirements of your subdivision land development ordinance. We understand the concern with this neighborhood school, but it has been a neighborhood school. It will be a neighborhood school going forward. It's unfortunate that today we have the traffic congestion we have everywhere. We're hoping that by adding the parking spaces in the front to provide for additional queuing, additional parking in that area, and also to have the turns on and off of Sundale Drive, it addresses some of the concerns that the residents have raised. Obviously, the school will be there. There's going to be traffic, and there's going to be construction, and there's going to be a disruption. We understand that, but we've done everything in our power to try to mitigate that to the best of our ability. So if anyone has any questions, we're happy to hear them tonight and answer those. Otherwise, we believe that we've met our burden. Thank you.
Thank you.
So you asking us to take action on the plan, and the waiver is a preliminary final is what you're talking about, right?
Yes.
Okay. So, Mr. Chairman, the school district has requested the township take action on the plan. The plan is identified as plan number LD 2024003. Before you get into the substance of it, you should deal with the waiver. So the waiver, as it I think is in the engineer's letter, it's a modification is requested to allow the submission of a preliminary final plan rather than a preliminary plan before the consideration of a final plan for this project, and that's the waiver that the Solicitor Jones requested. And so then, if there's, Chairman.
Do I have a motion to approve or disapprove the waiver?
Mr. Chairman, with regard to LD 2024-0003, I move to approve the modification of the submission of a preliminary final plan rather than preliminary plan before the consideration of a final plan for this project.
Second that.
I have a motion and a second. All in favor?
Aye.
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 So, Mr. Chairman, next, I see it as there's three primary issues that Solicitor Jones had mentioned. One is the school district requested that the township permit the school district to build on the township stormwater easement. The second one is the school district has requested that the proposed exit on Sundale be made left turn only. The third is the school district has recently requested that the township adopt some type of no parking ordinance on Sundale. With regard to the easement, I previously forwarded a memo to the township manager and the school solicitor concerning my opinion that the school district cannot build on the township's easement minus some additional agreement, sort of like what Solicitor Jones suggested, but that's discretionary from the township's perspective. With regards to the left turn only issue that's identified as on the engineer review letter as a deficiency. With regard to the no parking or some version of a no parking ordinance, the recent plan submitted by the school district requires a township ordinance that's not currently in place. In other words, the plan cannot be approved without a new ordinance. With regard to adopting some type of no parking ordinance on Sundale, that's discretionary, up to the board.
Is there a motion from the board to adopt a no parking ordinance on Sundale?
Mr. Chairman, if there's no motion, then you just move along. So finally, the school district has requested that the township take action on the approval or denial of its plan. So if someone wants to make a motion on that, they should.
Is there a
do so.
motion?
Mr. Chairman, with respect to LD 2024-0003, I move to deny the school district's plan based on the township engineer's review letter dated December 4th, particularly relative to the turning and the inability to do so without a no parking ordinance.
I'll second that motion.
I have a motion and a second. All in favor?
Aye.
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 Carries unanimous. We'll move on to communication from supervisors. Anything from anybody? All right, we'll move to solicitor's report. James, sorry to catch you on your way back up there.
No worries, Mr. Chairman. You have a copy of my report. Can I answer any questions that the board may have?
I'm good. Except I just lost my agenda.
All right, no questions for the solicitor, so we'll move on to manager's report. Mark?
I do not have anything to add to my report.
Any questions for the manager? Next, we have ordinances and resolutions. Ordinance number 2025-10, amending zoning ordinance clarifying interaction of flexible development overlay with other zoning districts. Any discussion on this?
Mr. Chairman, I think we heard from the,
Did you make it a motion to go to approval on it and then discuss, or?
We made a motion to.
We moved it to the
allow
agenda.
us
Yes, you
to
moved it to the
approve
agenda,
it.
so are
Yes.
you bringing this to the table for approval, and then you're going to discuss?
That's the appropriate thing to
That
do.
would
That's
be
what we're doing.
yes, I just want to make sure we're
right.
following the appropriate procedure.
So, motion
Mr.
to
Chairman,
bring it to
with
the table.
regard to ordinance number 2025-10, amending the zoning ordinance clarifying interaction of flexible development overlay with other zoning districts, I move for approval.
Second.
Now we can go.
All right.
Public comment. Or no, supervisor comments. Sorry.
Supervisor discussion.
Yes,
Any
yes, thank
discussion
you.
on this?
I think we heard from the applicants today, and I think that where we are with regard to the development project that is somewhat a prisoner of the moment. In other words, it's governed by the ordinances in effect today, that this tool will be very helpful to foster that particular redevelopment activity. However, it is completely at the discretion of the supervisors. And for that reason, I think I can support it for the flexible development window. And that does not derail any of our efforts down the road to enact some zoning changes as a result of our comprehensive planning efforts.
Other comments? I have a motion and a second. All in favor?
Aye.
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 Aye. Thank you. Next, we have resolution number 2025-59. And this is authorization to enter into collective bargaining agreement with the Springettsbury Township Police Officers Association for the period January 1, 2026 through December 31, 2030.
Mr. Chairman, I just wanted to add that the association voted the other day to approve.
Mr. Chairman, with regard to Resolution 2025-59, I move to approve the authorization to enter in the collective bargaining agreement with the Springettsbury Township Police Officers Association for the period January 1, 2026 through December 31, 2030.
Second.
I have a motion and a second. All in favor?
Aye.
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 Resolution number 2025-60, 2026 budget adoption.
I'll move for the adoption of Resolution 2025-60, the 2026 budget.
Second.
I have a motion and a second. All in favor?
Aye.
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 Resolution 2025-61, 2026 tax levy.
Mr. Chairman, I move for adoption of Resolution 2025-61, the 2026 tax levy.
Second.
I have a motion and a second. Just for everybody's interest here, we have not raised taxes. I have a motion and a second. All in favor?
Aye.
Aye. Resolution number 2025-62, approving YALFR budget.
Mr. Chair, I'll move for the adoption of Resolution 2025-62, the 2026 YALFR budget as presented.
Second.
I have a motion and a second. That pause gives me pause. Is there any discussion?
I'll defer to the delegates to the commission on that one.
Pretty straightforward budget, nothing controversial.
We have a motion and a second. All in favor?
Aye.
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 Any old business items that anyone would like to discuss? We have 11th Avenue and Whiteford Road sidewalks, and we have America 250 PA celebration. Anything that we need to discuss on either of those two?
No.
Okay. New business, acknowledging the receipt of a letter of resignation from Timothy Staub from the Planning Commission effective December 2nd, 2025.
Mr. Chairman,
Move to acknowledge receipt of the letter.
Second.
Motion and a second. All in favor?
Aye.
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 Next, we have discussion and possible appointment of a member to Planning Commission.
I think we're fortunate that, I don't know exactly the dates, but we interviewed Brian Kaufman at one point for a position on either planning or zoning. He's been serving on zoning as an alternate, which is my opinion, a very poor use of his time. And I would recommend that the board consider appointing Brian Kaufman to the Planning Commission.
Would you be so kind as to turn that into a motion?
I move that we appoint Brian Kaufman to the Planning Commission for to fill the current vacancy.
Second.
I have a motion and a second. All in favor?
Aye.
Aye.
That brings us to the end of our agenda. Meeting is adjourned. Thank you, everyone.